Hi, everybody. I'm Adam Rossen from the Rossen Law Firm, and today my portion of this DUI CLE program is going to be about the basics of DUI science and the standardized field sobriety exercises. And these are two very important parts of DUI cases. In my opinion, some of the most important parts. So it's my pleasure to really take you guys through this. So first, we're going to start really with the standard field sobriety exercises, the SFEs, the SFSEs, whatever you want to call them. That's really going to be the first half. And then the second half will be us talking about the science. So blood, breath, and urine tests as they relate to DUI cases. So as we're going to go ahead and start with the field sobriety exercises or the roadsides, I want everybody to really understand and know that these are exercises, not tests. So what that means is there's physical skill and dexterity involved in these exercises. There is no pass-fail. They don't look at it like that, and you don't want them to be considered that. And these are not done to prove somebody guilty beyond and to the exclusion of every reasonable doubt, like at trial. These are done by the police officers on scene to establish probable cause to make an arrest. And there's a very big distinction with these two issues, and especially when you folks are, when you're going to trial on these cases, you really need to establish that and make sure that the jury understands that the goal of these is to have a police officer decide if there's probable cause to make an arrest, and that does not necessarily mean that there's enough evidence to convict somebody at trial under the guilty beyond a reasonable doubt standard. So what are these standard field sobriety exercises? Well, they're divided attention tasks that are designed to measure somebody's, and we put it in quotes here, normal faculties. The thing that you really need to know and you need to be able to impress upon, whether it's a jury or, whatever it is as you're defending these cases, is that these are abnormal exercises that are designed or intended to measure somebody's normal faculties. And what are people's normal faculties? Well, the law actually defines them in the state of Florida for DUIs, so that's fantastic. The law defines them as the ability to see, hear, walk, talk, judge distances, act in emergencies, make decisions, and drive a car, and perform the many mental and physical tasks of our daily lives. So these are, these exercises don't really measure those things. Police officers, right? Are they abnormal or irregular? And some police officers will try to say that they're completely normal, right? And what you want to do is you really want to on cross-examination, you really want to cross these police officers and ask them, does a person normally walk in this heel-to-toe manner? Do they normally turn with a series of small steps by keeping their left foot planted on the ground? Because if you do the walk and turn correctly, when you hit that front nine, your left foot should be planted, and then you will be making a series of small steps to turn around. Who does that in their normal daily lives, right? Does a person normally put one foot up 6 inches in the air with their arms down by their side? Okay. And here we have, what I said earlier, right? This is Florida's statute, of the definition of normal faculties. It's not pass-fail, and these must be done on a flat, well-lit surface, free and clear of debris. And that is very important, as we'll talk about in a little bit. But you have to scrutinize these. Do not rely on the police officer's reports, really for anything, right? But especially to say that, well, it was flat, it was well lit, and the surface was free and clear debris. Because I can tell you in over 15 years of practice, quite often we've seen that is just not the case. And police officers for whatever reason, they don't do things properly. Now, these exercises, these field sobriety exercises, are non-testimonial in nature, so Miranda rights do not need to be read prior to them. And there's 5 exercises that are generally used. It could be 3, it could be 5, it could be any combination. 3 of these, the first 3 on the list, are officially recognized by NHTSA, which is the National Highway Traffic Safety Administration. They're the ones that really came up with the field sobriety exercises and did some of the the studies surrounding them many years ago. You also need to know there are seated exercises. Seated exercises are available, but they're rarely ever used. And you know what? That's not my problem. That's not my client's problem. That's the police officer's problem when they choose not to use those. It's the prosecutor's problem. So what do I mean by that? Well, these seated exercises need to be used when somebody has an injury, an illness, a disability, one of those 3, something going on with their legs, back, ankle, anything that would prevent them from doing these exercises, standing, walking, balancing, and when they should be done in a seated position to make it more fair. And what we see quite often is that the police officers don't do them. When somebody says that they have an injury or a disability or something. Now, the question is why? Why don't they do them? Well, could be many different reasons. Sometimes they're just not trained. Sometimes they are, but they just choose not to do them. Maybe, my hypothesis is because they're lazy, is because it's actually better for the defendant on video, because jurors can't really get their heads around these exercises like they can in understanding the walk and turn or a one-leg balance at least. But regardless, that's not our fault. It's not our problem. It's the prosecutor's problem. It's the police officer's problem. So when we're talking about trial, don't be afraid to cross them hard on this issue. These are very important tools that we can use to our defense. Now, this picture is not the best quality, but the reason that I have it in my slides is this was a clip or a shot from one of my cases. Now, this case, if you look and see, this is from a dash cam. This is from Florida Highway Patrol, and the patrol officer and my client's faces are blacked out or pixelated over. But what do we see in this background and the foreground? We see puddles, okay? You can't tell in this that it is raining. It's lightly raining, so it's not pouring. But what do puddles mean? Puddles mean that this area is not flat and level because water seeks its own level, right? He's standing in a puddle right now. If you look closely at the police officer's hand, it's actually at his face. And the reason it's at his face is because in this screenshot, he's wiping raindrops off of his face. So here we have it where this trooper asked our client or had our client do these field sobriety exercises while it's raining on an area that is clearly not flat and level while he's standing in a puddle. And as I said before, this happens far too often. Now, in this particular case, we went to trial. In this particular case, this was a big feature of my cross-examination of this trooper. And in this particular case, the judge actually granted our judgment of acquittal motion after the state rested their case. So the judge completely threw this case out, dismissed this case back on a lack of impairment issue because of this, and combined with other factors that were going on with the case. So understand, when you're dealing with these type of situations, you must scrutinize this video very carefully that you get, and you're going to want to look for these things and exploit these issues in your case. So let's get into the field sobriety exercises. The first one is called the horizontal gaze nystagmus. Now, that sounds like a fancy, not even legal term. That's a fancy medical term. Well, we kind of call it the follow the pen exercise. In Florida, some district courts of appeals allow the police to talk about the medical terms and nystagmus, which is the involuntary jerking of the eye. Other jurisdictions don't and will just let us describe the follow the pen. And the police officers cannot even talk about nystagmus. All they can talk about is a client's behavior during the exercise, meaning are they swaying? Are they moving their head instead of just moving their eyes? Those sort of things. Now, let's just briefly talk a little bit about what nystagmus is, just so that way you folks have a basic understanding. So, long story short, the horizontal gaze nystagmus, this is a test that really is done by ophthalmologists. There's roughly 45 different medical issues that can cause somebody to display signs of nystagmus, and alcohol consumption is one out of those roughly 45. Okay. What nystagmus is it's the involuntary jerking of the eye, and as the police officers are moving the stimulus, what they're looking to see is your eye jerking like a dirty windshield wiper or a dry windshield wiper. So instead of smooth tracking, it's going to jerk, kind of like that. Now, when you're defending against these, the police officers, there's a lot of guesswork. In order for them to do this correctly, they have to make a certain number of passes on each side. It really takes a few minutes to done right. So if you see the officers moving very quickly and doing this in 30 seconds, it's not a proper HGN. They're supposed to have their stimulus between 6 and 12 inches apart from your nose. Well, how do we know that this is between 6 and 12 inches and this, right? Which one's accurate, which one's not? And depending on how far away they are, also has an effect on the 45 degree angle or prior to 45 degrees, right? So how do we really know what that is? So there's great methods to cross-examine police officers on this issue if you dive deep and truly understand the HGN, if that jurisdiction that you're in allows the officers to talk about it. A great resource is Duane's, DUANES, which is a medical journal. It's not a medical journal, it's a medical textbook by this guy named Duane. That is one of the foremost medical textbooks in the ophthalmology world, and that really goes deep into the HGN. If your jurisdiction does allow police to talk about that, if it's pretty easy to become more knowledgeable about these issues than the police, because the police just read off of and regurgitate what they were told. They can't explain the hows and the whys, right? So when you cross-examine them, really hammer home that they don't understand how it truly works. They don't understand hows and whys. They just are regurgitating what they've been told by a class that they took. Maybe it was a 40-hour class. Well, you know what? That's 8 hours over 5 days. That's nothing. Okay, so that does not make them an expert. And even if the police officer is a drug recognition evaluator, that does not make them an expert. And you can get some gold by cross-examining them. And the best way to do this is really to practice at a DMV hearing, or if your jurisdiction allows depositions. If you can get a deposition on the criminal case, then that's fantastic as well. And that's something that you're going to want to do. So the next field sobriety exercise is the walk and turn. And what they do is they put you in this instructional stance. And if you take a look in this photograph, that's the instructional stance, which is a hugely difficult thing to do. It's a huge pain in the butt. Okay, you can't begin early and you can't start, quote unquote, practicing. Because if you start early, they're going to say that your mental faculty of ability to follow instructions was impaired. Because what the police do is they're going to rapid fire questions or instructions at you. And you're supposed to stand there with one foot in front of the other, with your arms down by your side, listening, processing all of this information without the ability to practice or to do. And it's very crucial that you folks look at this from a common sense or a real life person's perspective of how they learn things. And that's one of the common themes that I continually use in my DUI trials when this is at issue. We don't always want to attack the field sobriety exercises, but in the majority of our DUI trials we do, and that becomes a theme. And if you're going to attack the field sobriety exercises, you really need to not think of it as a lawyer. You need to not think of them as the letter of the law. You need to think of them as a common person, right? AKA your jury would view them, okay? And understand the stress and anxiety and the entire situation that your client is going through, right? So there's lights going on. It's late at night. There's a lot of people, a lot of police officers. Your client may be mentally thinking about something else, such as, am I going to be a no-call, no-show tomorrow at work? Does that mean I'm going to lose my job? I'm a single parent. How is that going to affect my children? Or I've been a law-abiding citizen for 40 years in my life, and you know what? I'm terrified to be arrested, right? And I don't want that to happen. So there's a lot of things that can happen that we really need to make sure are avoided at all costs. And things that are going on in their mind that can really affect their performance. But what you're supposed to do on this particular exercise is take 9 steps forward, heel touching toe. Then you're supposed to turn, and the turn is supposed to be a series of small steps. And then take 9 steps back, heel touching toe, with your arms down by your side the entire time. Every little thing you do that is not 100% perfect, they're going to count against you or say that that is a deviation, and they're not going to say that you failed, but they will say that they took that into consideration, whether or not or in their determination of whether or not your normal faculties were impaired. And the more that you truly understand how these exercises are supposed to be done, the better you'll be able to attack and defend it in your client's case. These should be on video, whether a dash camera or a body camera. And you're going to want to really look at and see, well, is there evidence, or did the police officer write in their report about all of the fine little details? Was there a gap on any of the steps? If so, how much, right? Can we all agree there's a difference if there's a gap between heel to toe this much or this much, right? Did it happen on every step or just 1 or 2? If it happened on 1 or 2, which ones? Because there's supposed to be 18 steps. As far as the turn goes, who does it? Well, as far as anything in this, who does this normally, right? Who normally walks this way? Who normally walks heel to toe with their arms down by their side? So there's a lot of common sense arguments that you can make in front of a jury at a trial to really attack these exercises. Specifically, specifically the walk and turn, but all of them. One thing that I like to do in all of these cases is I like to count up and separate each and every instruction, because there's, on some of these, there's between 10 and 20 separate instructions that our clients are supposed to remember and do perfectly. So again, think about these as common sense arguments. Now, this next slide is the one-leg stand. Okay, this is the third of the 3 standardized ones. And again, when you're being rapid fire given these instructions, you're not to begin early, you're not to practice. You have to raise your legs 6 inches off the ground, keep your arms at your side, and count to 30 seconds, 1001, 1002, 1003, etc. If you put your foot down, you're supposed to put it right back up and continue counting. Now, the same ways to attack the other exercises, you can attack this. This is not the way that we normally do things. So the police are putting us in an abnormal situation to try and test our normal faculties. The logic is just not there. It does not make sense. Um, Nobody does these things in their normal daily life. And one of the ways that you can try to even backdoor in the fact that your client maybe has never been arrested for DUI before is ask the officer, when you're cross-examining them and say, well, isn't it true that our client's never done this before? Or you don't know if our client's ever done this before, have you? So this could be very well the first time that he's ever heard these instructions. This could be the very first time in our client's life that she's ever had to do this, right? And one of the things that I really love on our DUI trials, when I know that the theme is going to be that we're attacking the exercises, which again is not always the theme. I love to have teachers, managers, trainers, athletes, coaches on my jury. And a lot of other people, lawyers who lecture on this, they say they don't want those type of people because they're very judgmental. Well, I found that if we are attacking the exercises, that I like to have people who understand how others truly learn. So, for example, I was a high school basketball coach for 10 years. And I understand that, well, quite frankly, some people are smarter than others. Some people learn quicker. People learn by different modalities. Most people need to try and fail multiple times before they truly understand or get something, especially when we're talking about the pressure of being on the side of the road with an arrest hanging in the balance, right? This is not a perfect ideal condition test environment where nothing bad will happen to you, where you're fully rested. There's no other environmental or mental or emotional factors going on like there is in real life. So when you think about this less like a lawyer and more like a human being, it really helps you relate to the jury so much better. Now, the fourth exercise is the finger to nose, which is not NHTSA approved. And there's really two different ways to do this. And this picture has really the old way of doing it with your arms, by your out. Now they can have people with their arms down, but really it doesn't matter. This, I think, is one of the absolute hardest exercises to do, and you're not even moving in this one. You're not balancing, you're not walking. And the reason is these officers can be very petty. So if you take a look at me, right, you're supposed to use the tip of your finger to the tip of your nose. And in most instances, when our clients do this, they're actually 100% wrong. And quite often I've seen clients do this and the officers say, oh, I'm sorry, you didn't do it correctly. And I've seen our clients sometimes get upset. And the reason is because this part of my finger is the finger pad. This is the tip of your finger. So when the officers demonstrate, they demonstrate the correct way. But look how petty this is, the difference between the tip and the pad. And so I often lecture about this, and I often use the finger to nose as the example because it is such, a petty difference between the pad and the finger. And most people aren't thinking about that, even in perfect ideal conditions. So it really, to me, it does seem as though kind of like a gotcha moment that the police officers use. Okay. Now, what are they looking for? Well, they're looking for to see, is the tip of your finger touching the tip of your nose, not your mouth, not your bridge, not a nostril, not the pad, not the side of your finger. They're looking to see balance. They're looking to see, are you able to bring your arm back down or back to the side as opposed to just leaving it there? And do you get your right and your left correct? So there's a lot of things. They're also looking for balance and swaying issues as well. Again, just like all of these, I believe common sense wins. not the technical nature of the exercises. Because, if the case does go to trial, you're dealing with normal people that, you want to screen for common sense. And the last field sobriety exercise is called the Romberg balance. Basically, it's stand and balance. Stand, balance, close your eyes, tilt your head back, and estimate 30 seconds. Okay? What are they looking for in this? Well, they're looking to see if you have eyelid tremors. They're looking to see, did you estimate 30 seconds correctly? Did you estimate 15? Was it 45? Was it 2 minutes? Or was it 33 seconds or 26 seconds, right? They're also looking to see, your balance, just like all the other exercises. Is there a sway? Do you open your eyes? Do you follow instructions or not? So, even though on, practically, in practicality, the Romberg balance is probably the easiest and least complicated. It still has some complicated things you have to do, and things that, in my opinion, don't really demonstrate whether or not somebody is impaired by alcohol. So some questions, right, that you folks can ask, the police officers either during a deposition or a Bureau of Administrative Review hearing. Ask them how many times it took for them to practice these before they could do it perfectly, right? Because they're not usually going to say, oh, somebody must do it perfectly, but in reality, that's what it is. That's what you want to establish, that it took them multiple times to practice to get better. You could choose to do it, as an open-ended question. You can do a hard leading question, if you really want to cross them hard, but you want to ask them about all of the correct normal actions, also that your clients completed. So if we're talking about 17 different instructions, and the client did 14 of them correctly during on the field sobriety exercises, well, then you want to hammer those home, right? You also want to talk about all of the normal things that your clients did during the entire DUI investigation. So if we're looking at these exercises as abnormal ways to decide somebody's normal faculties, well, let's think about this again logically, like a normal person. Wouldn't showing, let's say there's a dash camera and it shows the stop, right? If our client, we can see on video that the brake lights come on within a second or two after the police lights are activated, and our client gave the license and registration quickly, exited the car normally, walked over to the field sobriety exercise area normally, didn't have a sway or balance issues, isn't that, if you have those facts, isn't that a better indicator of somebody's normal faculties than these abnormal exercises? And if you don't have that on video, well, you can get a good idea of whether it happened or not from the reports. So what do we mean by that? Well, the officers are trained to write everything that your client did incorrectly or poorly in their police reports. So if there's nothing in the report saying that your client had problems or a delay pulling over, well, then you should assume that your client did brake quickly, did pull over in a quick, normal, and safe manner, right? And if the officer, upon questioning, says that your client didn't, well, then that's further ammunition in cross-examination to talk about why didn't the officer write that in their report? And how do they remember that months later? And talking about the fact and their training that they are supposed to write everything in the report. Because if the officer is trying to be cute and say, well, I don't know if it did or not, well, then, you can go really hard into that level of cross-examination about writing a poor report, because that report is supposed to refresh their recollection months later in a trial. Or if the officer's honest and straight up and says, hey, look, you know what? Client must have done it correctly because I didn't mark it down. Well, then then that's fine too, right? And that's obviously going to be good for you. So you're going to get some really good, cross-examination data or information to use on cross from these things. When you think about it from just a practical human being standpoint, not even a lawyer standpoint, right? What's a better indicator of people's normal faculties? The way that they're supposed to drive and the way they're supposed to react to being pulled over, or these, cockamamie exercises that NHTSA just made up, right? So that's very powerful in these cases. Now, this is huge, and this is quite often a very big theme of my cases. Not always, but obviously it's got to have the right context. But when we're attacking the field sobriety exercises, officers often confuse average with normal. Actually, not often, they always do. So the measurement standards are not one size fits all, and the difference between average or normal is this. Well, everybody who's on this webinar, you take, I don't know, let's just say you take 100 or 20 of your closest friends and family, right? You take, you could even say everybody who's in the courtroom at that time. And if you took them all together and kind of mixed them up and sliced them in the middle, well, what would you get, right? That's the definition of average. You would get an average. Not one single person, whether it's a cohort of 20, 100, or whoever's in your courtroom, would be that average person. That would not be anybody, right? So what they're doing is they're confusing the words average with normal, okay? We are all our own version of normal. What does that mean, right? Well, our speech. We don't all talk the same way. Some of us are from foreign countries. Right? We talk differently. Some people are mumblers. Right now I have a bit of a cold, so my voice today is not the way that it normally is every day. People act differently under stress. There's many environmental factors to this. People in, Florida don't talk the way people from Chicago talk, right? Same thing about the way that we walk in balance. Same things with our mental faculties, right? We don't learn the same way, okay? Think about yourself. Are you the type of person that's cool and calm under pressure? Or are you a nervous Nelly? And either one's okay. It's just a matter of how do you do things, right? Some people, whether they're cool or calm or nervous, is situational. But just because somebody's cool and calm and somebody is a nervous Nelly does not mean that that's not the way they normally are. And think about it like this. I've been on this webinar, 15, 20 minutes. Are you folks in a position to judge my normal faculties? Absolutely not. So how long are the police, or do the police have to judge your client's normal faculties? 10, 15, 30 minutes? What I often will say, to the extent that a judge will let me in voir dire, but especially in closing argument, is have you ever met somebody who at first you thought that person was amazing, and then you realize that person's just not who you thought they were, right? And I said that once at a different lecture, and a lady in the front row started laughing, and she said, yeah, I married the bleep, right? And the bleep was not an endearing term. And everybody laughed because we realized that first impressions are often wrong. And when you break this down into just psychological human elements and understanding, the jury really can understand. The prosecutors and police, they're going to be robots. They're going to think and act like lawyers. And your job as the DUI defense practitioner is to not think like a lawyer, is to think like a common sense human being the way that your jury thinks, and be able to attack these exercises from a common sense, normal person's thought perspective, because then they will truly understand and get the issues. Now, I'm going to go back a slide, because when we're, again, another way to attack these is when we talk about prevention versus affected performance. So the officers, a lot of times what they're going to say to a client is, well, is there anything that would prevent you from doing these exercises? Well, yeah, sure. If you had a foot amputated, you couldn't do some of these exercises, right? But if you had a bad ankle, it would affect it. A torn ACL, a bad back, shin splints, right? And most of these officers, they're not asking if, they don't go the full way. They don't say, do you have any knee, back, ankle injuries, anything that would affect your performance, negatively affect it, right? A lot of them are just trained in, hey, do you have any injury, do you have any disabilities that would prevent you from doing this? Well, there's a huge difference between disabilities and injuries, right? And there's a huge difference between prevention and being effective. So you have to really understand and be able to critically attack these, because you need, again, normal people are going to be making these determinations, right? And the further of a wedge that you can drive between the prosecutors and the police is not being normal people or not giving your client a fair shake, the better it's going to be. And these are great points for cross-examination. And again, these seated exercises. All right, so in the context, this is one of my cases that we had. And this was the walk and turn exercise. And what I did in this particular case was I counted out, and I talked a little bit about this a few slides ago, but what I did was I counted out each and every instruction on the walk and turn. And I separated each and everything, super granularly, right? To the point where I determined there was 17 separate instructions on this. And if you see, I wrote them all out here. And what I did in trial was I broke each and every one of these down separately. It was a bit monotonous. It did not have, the big Perry Mason moment at the end. But what I did was I went through each and every one of these, hyper detailed. And I had in this particular instance, it was a community service aide who had my client do these exercises back at the station, not on the roadside. And she admitted that my client did 14 out of these 17 correct. Now, doesn't that sound better, significantly better than just focusing on 3 things that the client did wrong and saying that they were looking for, a certain number of cues, or that they found that there were 3 cues that, that my client failed, or, did not do to standard, right? Because they won't say failed. But he did 14 correctly, right? And when you really put it in those terms, it's a lot more persuasive. And here's what I talked about earlier. For some DUI cases, the clients do pretty well and they don't look like they're, hammered, right, or wasted. Maybe, the theme is that they were slightly or moderately impaired. Maybe there's a breath case as well on this. That's over the limit but not too high, right? We want teachers, coaches, managers who understand how people learn and understand that people learn by failing, learn by doing things incorrectly, using that common sense. When this has been the theme, it's a very powerful theme of the case. So that's really it for the beginning portion, or for the first half, as we're discussing the field sobriety exercises. What I want to do now is transition into the breathalyzer, and then we'll talk a little bit about urine, and we'll talk a little bit about blood. And understand everything that we're talking about here today, these are basic, introductory level discussions. If we were to go to more of an advanced level, that would be the topic for its own seminar, which, we have no problem, maybe we can even do it at a later date. But really, this is just to give a really good overview, so that way the new DUI practitioner can understand that, hey, these breathalyzers are not these big mythical things that cannot be beaten. Quite often they can, and they are beaten when you know what you're doing. So let's talk and let's learn, what is the intoxilyzer 8000, right? The breathalyzer. Well, first of all, don't be afraid of a high breath test. It's once you know what it is, it is what it is. So let's talk about it, right? So this was first manufactured in 2001, so over 20 years ago. It's been used in Florida since 2006. That's when we had the Motorola Razr, the Nokia flip phones. We had the Nextel walkie-talkie, the Sprint Nextel walkie-talkies, if you remember that. The Windows operating system was Windows Vista. And the technology that it uses is infrared microwave radiation technology from the 1920s. So it's over 100 years old, this technology. So when you can, again, break this down in common sense terms, it resonates with the jury. The first iPhone came out in 2007. The first iPhone didn't even have copy and paste functionality, and there was no app store on the first iPhone. That came out in 2008 with the second iPhone, the 3G. So, if anybody of you in here are old enough to remember those things, technology moves at a lightning fast pace. But yet, the technology involved in these machines does not. So the picture on the right, the two pictures on the right, okay, are important. The top picture shows one of the very first breathalyzer contraptions with a balloon and these tubes and and all these kind of crazy things. And the picture on the bottom right of the intoxilyzer 8000 pretty much has the same kind of things inside, just it's hidden inside this box. Now, one thing to note is the intoxilyzer 8000 is portable. It has a handle on it. You can see the handle in this picture, which I'll get to later as we talk about the time of driving argument that we're going to have. There's a keyboard. It's, for all intents and purposes, it's a computer. It's a computer that's 20 years old, that's running on 20-year-old operating software. They don't like to call it a computer. They call it an instrument. I still don't know what that means. I still don't know why they call it that. My assumption is they think it sounds fancier, or it actually gives it more credibility. I don't know. But if you ask them, they'll say instrument, and most of the people that we've cross-examined can't even tell you why. Can't even tell you why they call it an instrument. So, to me, it's a computer. And if you've ever heard one operate, it sounds like a a mid-1990s AOL dial-up. So a pre-Ethernet computer or modem, which, again, for jurors, common sense, they're hearing it go, right? Like that old school, like you're logging into AOL in 1997 here. And when you're able to relate that back to something like logging into AOL in 1997, it really resonates with common people, common sense, normal people, how old and ancient and unreliable this technology is. So what we're going to talk about today with the breathalyzer is just a few different issues and common areas of unreliability. We're going to talk about breath temperature. We're going to talk about partition ratio, margin of error, time of driving, the .020 agreement, and source code. So let's go into breath temperature. Just like in the field sobriety exercises, how we talked that they confuse average with normal. Well, guess what? They do the exact same on this with the breath temperature. So the machine does not have a separate breath temperature sensor. And what it does, it estimates the breath temperature at 34 degrees centigrade, which is 93.2 degrees Fahrenheit. Studies have shown that higher breath temperatures will increase the breath alcohol level and lower temperatures will decrease it. And a study in 1995 that was a scientifically valid study of 700 subjects found that most people, or actually everybody in the study, the temperature range, breath temperature range was between 33 and 36.7 degrees Celsius. And the study recommended if they had to use an average, that the average should be 35 degrees instead of 34. And if that's true, which the study shows that it is, then the intoxilyzer 8000 is overestimating or creating a false positive on every single breath test. Okay. And that, when you can break that down in layman's terms, that's huge. And, again, when you can cross-examine on all of these issues, not just the breath temperature, but these breath techs and these supposed, experts that they bring in. Now, first of all, you want to know what they're going to testify to, so that's why you should subpoena them for the DMV hearing, and if you can get a deposition or two, whether it's this case or a previous case, that's fantastic because you want to know what they're going to testify to. But if they're not able to really explain the inner workings, which most of them aren't, they're going to look terrible. They're going to look like they're just police officers that are coming to regurgitate facts. And it's something that a jury can't see, hear, feel, or touch. And so what I found is most of the time when people can't really wrap their heads around something, when it's more amorphous, they just will not put any weight into it. If they can't understand it, it's gone, right? If they can't really feel as though they know how it's working, they're just going to say no thank you, and get rid of the whole thing, or not count it at all. The second thing is partition ratio. So this is a ratio to convert breath to blood levels. Okay, it's based on Henry's law. You don't really need to know much about Henry's law, but what it does is it assumes a closed system, and partition ratios, again, scientifically valid studies have shown that the partition ratios vary between 900 to 1 and 3,400 to 1. And according to a study in 1983, they said that the correct partition ratio is 1756 to 1. And same thing, when they are overestimating the partition ratio, well, then it's overestimating breath tests. So people that have lower partition ratios, right, actually are having a false positive on the breath test. Okay, so that's just two easy ways right there to understand that these things are creating false positives. And remember, it's not your job to prove what your client's partition ratio is, right? It's the prosecutor and the police officer's job to convince a jury beyond and to the exclusion of every reasonable doubt that your client was driving, or at the time of your client's driving, their breath alcohol level was over a 0.08. So all you have to do is grill them on these things. Even if you're getting, I don't know, I'm not sure, I don't know, as long as you can explain that to the jury, as long as you can seem more knowledgeable than the police officer or the breath techs, then the jury's going to, they're not going to count or put a lot of stock in what the officer's saying about these things. So that's very important. Now, there's a margin of error on these tests. So what happens is every month there's a monthly inspection, and then there's an annual inspection. And what happens at these inspections, CMI Corporation out of Tennessee, which is the manufacturer of the intoxilyzer series and the 8000, they send these dry gas canisters to the different departments during their inspection, right? And these dry gas canisters are closed simulators, okay? These are closed simulator solutions that are supposed to be perfect, okay? All of the solutions that they give. And what happens is, in perfect circumstances, which is what happens when CMI mixes up these canisters and solutions to hook up to the intoxilyzer to test them, right? Closed system, sterile environment. And what I mean by that is, contrast that to when a human being gives a breath test. Right? We all learned through COVID that how quickly air particles move, right? How quickly people can be sick from other people. Well, imagine if you're the 10th or even 4th person that night in that room giving a breath test. Sure, they change out the mouthpieces and so on and so forth, but there's alcohol in the air, okay? You're breathing in what other people are breathing. Your body, just as a human being, is not a closed system because things are coming in and out of your body, contaminants, pollutants, right? But yet these canisters, the solutions, are perfectly mixed. And when they're perfectly mixed and tested in a perfectly controlled environment, there's still a margin of error. And the acceptable range for the 0.05 test, it's a plus or minus 0.05. So that means these machines will pass the test anywhere from a 45 to a 55 on the 050 test. And on the 080 test, it's the same plus or minus 0.005, 5 points. So a 75 to an 85, anywhere in that range counts. And in the 0.20 test, it's a plus or minus of 10. So up to a 20-point swing, meaning a 190 counts as passing and a 210 counts as passing. So when you look at these numbers that I have on the left, right, 0.204, well, that passes. An 049 passes, right? 079. None of these are the same every single time, and this counts as a passing. So if the test has a wide margin of error with a closed system in ideal situations, why won't the police give a margin of error during the real thing, right? And the common theme that I have, and especially through this lecture, is the more that you can break this down to people as a common sense argument, the more they're going to understand and go, wait a minute, right? The defense lawyer doesn't have to prove to me that there was what the margin of error is, or how is it worse? Is it more or less for a human being in this situation? They just have to tell me, geez, wait a minute. Yeah, it doesn't really make sense. Perfect conditions, and there's these huge margins of error, right? You want people to be skeptical of the breathalyzer, the intoxilyzer. Now, the next thing that we're going to talk about, which is different than the margin of error, is what we call a 0.020 agreement. So it's a 20-point agreement. And what that means is, when your client is giving the breath test, they have to give 2 valid samples. And what you'll see is, most of the time, the 2 samples are not the same. Now, this argument doesn't work in every case, because if you have a client who blows a 151 and then 4 minutes later another 151, well, then, you're really not going to want to use this argument. But even if they don't, even if it's a 151 and then the second one's a 144, let's say, right? Or the first test is an 096 and the second test is a 101, right? They're not the same. And what the breath text will say is that they have to be within 20 points of one another. So what you can get them to admit is that an 079 and an 098 would both be considered valid samples under their rules. So the very common way to do this, right, common sense, so that way your jurors can wrap their heads around it, are using a scale. If you got on the scale and it said you weighed 79 pounds, you got off, you went back, it zeroed out, and then 3 minutes later you go back on that scale and it says you weigh 98 pounds, you would say the scale's broken. Easy. I mean, easy, no debate, no nothing, right? But what the police would do is they will tell you that that scale was working correctly, right? So that's another thing that you can attack. And, doesn't matter why that's the agreement or why that's allowed or not. That's just what, use their own rules against them. That's their rule. So if it's applicable in your case, use it because it does work. Another one of the things that we attack is time of driving. So as I showed you on that slide earlier, the intoxilyzer 8000 is portable. It does have a handle. And when we're talking about the time of driving argument, for DUI checkpoints and saturation patrols, they will quite often bring the intoxilyzer 8000 to the scene, to the roadway. So if they're going to bring it sometimes, why not bring it all the time, right? And what that goes into is, well, the prosecutors and the police have to prove that your client's breath alcohol level was over 0.08 at the time that they were driving, not at any point, not an hour or 2 hours later, but at the time that they were driving. That's what the law says, right? Not our problem, it's their problem. So you have to hold them accountable, and you have to, make the jury understand that they could and should have had that breathalyzer on scene, but they chose not to. Now, these days, more and more jurisdictions are having the breathalyzers on scene, whether it's, they're in, whether it's like a Suburban or a Tahoe or an Explorer, and they're going to have them there. But if they don't, and your breath test is an hour to 2 hours after, well, that's fantastic because, we don't know if the client was absorbing or eliminating alcohol. Generally it absorbs and eliminates on a bell curve, but it's not our job to prove that. We have no idea. And they're not going to bring in an expert on a misdemeanor DUI case to try to do Widmarks or a retrograde extrapolation. They're just not. And, you can look, for this level, it's not, we really don't need to go into Widmarks or retrograde extrapolation, but basically it's about trying to relate back to see what the breath alcohol level was over time. And that's exactly why in DUI manslaughter cases, when they do blood draws, they'll usually do 2 blood draws an hour apart to really, get a much better idea of what's going on with your body. And of course, they'll have medical experts to try and testify to those things. But on these, they're just going to have 2 breath tests, 3 to 4 minutes apart, roughly an hour or 2 after you were driving when you were back at the station. Okay, so really hammer that home. And again, you as the defense attorney don't have to prove any of these things, right? It's their job to prove it. And they'll never be able to answer the why. And if you leave the jury wanting to know why they didn't do this, that helps a lot, because they're never going to get that answer from the prosecutors or from the police. And another good argument is, CMI, the corporation that manufactures these, they've never disclosed the source code, and they cite trade secrets, and they've won this battle in court over and over again. So let's use it against them. They're part of their agreement, their contract with Florida Department of Law Enforcement says that no police officer in the state of Florida is ever allowed to open up the intoxilyzer. So ask these officers, hey, you've never actually opened this machine, right? You've never, quote unquote, gone under the hood, have you? Right? Because, excuse me, when that becomes an issue, I love to have computer people or mechanics on my jury, people who are used to going under the hood to see how things work, to fix things. Even mechanics, nowadays they have the computer modules that just pop in right under the dash, under the steering wheel. But a lot of times those control modules are wrong, or all they'll do is give a surface level diagnosis. And if you ask any experienced car mechanic, they're going to tell you they don't care what that computer says. There is no substitute for them going under the hood and them seeing that for themselves based on their training and experience what's wrong, and them using that instead of what a computer says. If you ask computer people, Get them, and again, this could be a theme in voir dire, this could be something in closing, but computer people understand garbage in equals garbage out. They understand that the math is only as good as the equation or the algorithm, right? They understand that if you're talking about Windows Vista, it was a horrible software. Windows XP, Windows 2000, all of these ancient technologies, and they understand that technology moves so fast. So they're going to think, you're going to want them to think critically and say, well, wait a minute. These police officers have came in and explained to me that this mysterious thing is infallible, yet they have never gone under the hood themselves. Again, why? And they'll never give you that answer, right? So that's what you want from people. And so, again, don't be afraid to have that mechanic or that computer or tech person on your jury. Okay, so here we go again. Just if you want, and what you should do is you should be familiar with this link to go, especially if you practice in Florida, to go through the FDLE's alcohol testing program, and you can see all of the inspection data for that specific intoxilyzer. You can also see the subject test data for your client and everybody who gave a breath test that night or that year or that month from that same intoxilyzer. So you really, there's a lot more that we can go into the record aspect of it. That's a little bit beyond the scope of today, because I just wanted to give you guys some really good quick hitters to to really attack this. But go in and spend, you got to go deep, spend some real time looking at this on FDLE's website, right, or the department's website, to really understand these records. And here's a quote from a judge. So anytime we can use a judge's quote is fantastic, right? So this was a case in Orange County in Orlando from a decade ago. The Intoxilyzer 8000 is a magic black box assisting the prosecution in convicting citizens of DUI. The defendant is required to blow into the box. The defense has shown significant and continued anomalies in the operation of the Intoxilyzer 8000's operation. The prosecution argues most of the tests do not show anomalies. In fact, a high percentage of the tests may show no anomalous operation. That the Intoxilyzer 8000 mostly works, which is what the prosecutors are saying, is an insufficient response when a citizen's liberty is at risk. Now, I wish all judges thought this way, and obviously all juries, but that's pretty powerful when you hear that in case law from a case by a judge, right? That's very, very strong. And before we jump to the urine, there was a fantastic article that came out in the New York Times a few years ago that everybody on here should Google and just get familiar with. And it talks about breathalyzers in a few different states, Florida being one of them. And it just talks about all of the problems. And that's just good to read and to know and to understand, and get some background from that article, because that expose was fantastic. How's that practically going to help you? Well, you certainly can't cite to that article in a motion to suppress or at a trial, but even reading that will help help you come up with more ideas and understand and feel confident that that's all that this intoxilyzer is. It's just some magic black box that we don't even really know how it works. And if we don't know how it works and the cops don't know how it works, how can we expect a jury to really trust this, right? And that's the bottom line. So now we're going to talk a little bit about urine and blood samples. Urine is very important. Urine DUIs, when you know what you're doing, especially when we're talking about, obviously alcohol, but also drugs. Urine DUIs can be beat, very easily if you know what you're doing. So urine is nothing more than a waste byproduct of what was once in your blood. And the key word was once, right? So, excuse me. Think about this like a Ziploc bag inside your body, right? Yes, it is physically present in your body. It's there, but this is not influencing behavior, current behavior at all. because it is already the byproduct that is waiting to be eliminated through your urine, through, when you go to the bathroom. So this will tell you what at some moment in time was in your system, but you can't use this, or the prosecutors and experts can't use urine to say whether or not you were impaired. It's extremely unreliable. It's very difficult to extrapolate back to time of driving, and any expert witness that has any level of credibility will say that. If in your jurisdiction, the state's expert witnesses are saying that they can do this with urine, it is just simply not true. And there are a plethora of experts out there that will easily contradict this. Anybody who has any scientific level of credibility will be able to destroy them. If you get that witness if you have your own expert witness. But what you really should do is take a deposition, get leave of court to take a deposition of these medical so-and-so experts, if this is a urine DUI. Down in South Florida, in Fort Lauderdale, the chief toxicologist for the Broward County Medical Examiner's Office, he's a state witness, but yet he testifies as if he's a defense witness and says over and over and over again, he cannot and will not ethically try to extrapolate anything back or give any comment about whether or not the drugs were therapeutic or whether they were, intoxicating, or whether they caused impairment. He cannot and will not ethically. So when you have, the state's own prosecution working against them, or own experts working against them, it's pretty good for your case. And here's what I was saying before. It doesn't say when you had consumed the drugs or the substance. It doesn't say how much, and it doesn't say how you used it. So what I mean is, was it snorted? Was it injected? Was it smoked? All of those things, right, can change the way that prescription medication and illegal substances are, affect your body. Okay? And again, the big thing is that they cannot give an opinion on whether or not they were therapeutic or impairing, and understand one of the big differences between, prescription, drug DUIs, whether it's, especially for prescription medication, is there's no legal limit for drugs in a DUI case, even for illegal drugs, right? There's no marijuana legal limit in the state of Florida. Now, I understand the state of Washington has one, and I believe Colorado has it where it's now recreationally legal. But in the state of Florida, we don't. And how do we know what level for your client, not for the average or normal person, quote unquote normal person, but how do we know what level of alprazolam, which is Xanax, or what level of oxycodone, which is Percocet, is therapeutic versus impairing, right? How can the prosecutors prove it? They cannot. Just as simple. Now look, if your client's stumbling all over, vomits all over themselves, and looks extremely impaired, then the prosecutors might win on an impairment theory, but they're not going to win on on a urine, on a scientific theory. Okay. And as I said before, depositions of toxicologists are an absolute must. So let's talk a little bit and give a brief overview about blood samples. So you're only going to see these blood samples under the following circumstances. Really, DUI with DUI manslaughter or vehicular homicide, DUI with serious bodily injury, or if a breath test is impossible or impractical. That's really it. So let's go over some of these. Let's first start with if a breath test is impossible or impractical. So usually it's going to be a car crash. Maybe your client, usually your client will be at the hospital, and they're going to ask your client, in that situation, they can ask your client to consent. Okay. Your client can still say no. Okay. Your client can still refuse that. They cannot forcibly take blood in that circumstance, but at least they can ask if they believe it's impossible or impractical. Now, in a DUI manslaughter or a vehicular homicide where there's still, issues with alcohol or chemical or controlled substances or serious bodily injury, well, then they can ask, and they can also, in the state of Florida, get a warrant. Okay. And the warrant takes a little bit of time, but it's, nowadays they can get electronic warrants. There's always a judge on duty at all times, so they're pretty good about getting those. And really, those will be the different types of situations. Blood cases can be beaten. Okay, and a lot of times prosecutors aren't really equipped to defend against our allegations of Fourth Amendment violations with these blood draws. So you really need to go much deeper than we're going to talk about today, but you want to get an advanced level understanding about how blood DUIs work and how to beat them. Now, let's talk about medical records investigative subpoenas for blood. So, well, before actually I do that, let me kind of break this down. There's two types of blood cases, DUI blood cases. There's legal blood and medical blood. So medical blood is blood that's taken by a hospital or a medical provider for the purposes of medical diagnosis and treatment. So it would be, let's say you're at a hospital and the hospital wants to give you, Percocet for pain. Well, they can't give you Percocet if it's going to have a synergistic effect with alcohol or with some other drugs. So they're going to need to run a toxicology, screen to know, hey, should we give this person Tylenol or should we give this person morphine or Percocet, right? Because what they certainly don't want to do is kill you because of the synergistic effects of what's in your system and what they give you, because then that would be medical malpractice and obviously you would die and your family would sue the hospital and they wouldn't do that. So due to their medical oath, their medical treatment for that purposes, a lot of times they're going to take blood draw. That is what we call medical blood. Legal blood is blood taken, it could be taken still by a medical professional at the request of law enforcement for investigative and criminal prosecution purposes. Meaning if they get a warrant, that's legal blood. If they ask a client and the client consents, that's legal blood. So understand the difference between the two. Now, when we're talking about medical records investigative subpoenas, we're talking about medical blood. Okay, so when the state attorney or even the police officer through their investigative subpoena powers, when they're trying to get your HIPAA protected records, the law basically says that we have to do a balancing act between your client's HIPAA protected rights and medical records versus the state's interest in prosecuting a potential criminal case. So what the state must do is they must serve the client or the attorney with a notice of intent to serve a subpoena ducis tecum. And that basically says, hey, we're putting you on notice that we're going to, get these medical records and we're going to send a subpoena ducis tecum to the hospital or the ambulance or whoever to get your client's HIPAA protected medical records. You have 10 days to object. Always, always, always object. Absolutely. And in the state of Florida, the judge must set what's called a Hunter hearing. It's from a case called, State v. Hunter. Long story short, you're probably going to lose the Hunter hearing. As long as the prosecutors can prove a nexus between, the reason that they're seeking this and the criminal case, and that it's part of an ongoing investigation, they're going to win according to the law. But we make them do their work. We don't play the result, we play the process. The process is good things happen when you make prosecutors work hard for it. So what do we mean? Object, object, object. I've had cases where we've objected in writing, usually over email, or we can file a written objection, with the clerk. We've done it both ways. And the prosecutors just never set it for a Hunter hearing. It's not my job. It's not your job to set it for a Hunter hearing. It's their job, right? Let them do it. And if they don't, you be quiet and you don't say a word. Okay, and we've had cases that we've won in large part because the prosecutors were overwhelmed and forgot. And then we're ready for trial or a motion, and you know what? They're scrambling. They don't have their ducks in a row, and before you know it, they're coming begging to us to negotiate a reduced charge with their tail between their legs. Okay. Now, we've talked about the nexus. Force them to do it. Now, let's say you go forward with this hearing. I can tell you, there's been about 5 times in my career where I've won Hunter hearings. So it's still worth it even on the merits. Okay, it's unlikely, but you know what? There's a 5% chance to win. It's worth it. It's worth it, right? And even when we lose the Hunter hearing, what we ask that the judge get the records in camera. And then the judge goes through the records and then decides what is disclosable and what is not. For example, if your client has an STD or HIV or some other type of medical issue, that's not relevant in any way whatsoever to their prosecution. And the prosecutor should not have access to your client's HIPAA protected medical records. So what we do in our cases, we say, Judge, fine, if you're going to grant this, I understand. However, we want the records to go directly to you, Your Honor. We want you to review it and then decide what is disclosable. And if you have good judges, they'll do that. And what happens is judges are human beings. And we've had cases where that's happened. And you know what? The judge never followed up to make sure they get it, right? Maybe that it was sent out, the subpoena was sent, and who knows, the hospital didn't comply. Okay, fantastic. Judge certainly wasn't following up the way a prosecutor would. Or the judge gets it and it's sitting on the judge's desk under a pile of paperwork because it's not a priority for the judge. Fantastic, right? And the prosecutor forgets, the judge forgets, and again, doesn't matter, okay? Not our job. So we always want people to make people do the work, go the extra mile. And, again, for this, we're doing a very broad-based overview of breath, urine, and blood tests. But these are some really good tactics that will make a huge difference where you don't need to be truly at that advanced level. I want every DUI practitioner that's listening to this to get to an advanced level. You should, but when we're talking about beginner stuff, these tips and tricks should help you and get you a fantastic kickstart into your practice as a DUI defense attorney. Hope you enjoyed my part. Hope you enjoyed this entire CLE presentation. Remember, I'm Adam Rossen, the founder and CEO of the Rossen Law Firm. We help good people when bad things happen so they can achieve their best future. And we'd love to keep in touch.